The committee will come to order. Good morning. Welcome to our witnesses, our audience, and thank you for being here. Today we'll review issues related to reauthorizations of provisions of the USA Patriot Act that will fall within the jurisdiction of the House Permanent Select Committee on Intelligence. Primarily, those provisions deal with the Foreign Intelligence Surveillance Act, or FISA, and with the sharing of information between intelligence and law enforcement agencies. Because there's been so much public discussion and debate about the Patriot Act, I hope that today's hearing will serve as a reminder that many of its provisions are fundamentally intelligence authorities intended to gather information to counter threats to our national security from acts of terrorism and espionage. These provisions are designed to protect the American people. I also think that it's important to point out that the House and Senate Intelligence Committees, as part of our oversight responsibilities, receive detailed reporting on how the FISA authorities of the Patriot Act are used in practice. Although we do not discuss this reporting publicly, I want to emphasize that we conduct close and continuing oversight of these many Patriot Act issues. I also want to state for the public record that during our committee's closed sessions, there has been strong bipartisan support for renewing at least parts of the Patriot Act. And we'll find out for exactly what parts and for the totality as we go through this process today and over the coming weeks. In fact, we particularly appreciated the opportunity to discuss these issues in depth with Director Mueller as part of the Federal Bureau of Investigation's annual budget hearing. Today's hearing is intended to discuss what the specific provisions of the Patriot Act are and what they are not. The Act provides enhanced but carefully tailored authorities to support intelligence and terrorism investigations, usually targeted against foreign powers and agents of foreign powers. The Patriot Act also definitively breaks down the wall between intelligence and law enforcement agencies to allow them to share information free of artificial stovepipes that reduce the nation's ability to thwart acts of terrorism. As I believe that we will hear today, the Patriot Act actually provides more protections for American citizens than less, as some have claimed. What the Patriot Act is not, either intent or practice, is a license for the government to invade the privacy of ordinary citizens or to violate civil liberties. The Department of Justice Inspector General reported earlier this year that it had received 1,943 allegations of abuse of the Patriot Act. None of those complaints were found to have even alleged misconduct by Justice Department employees relating to use of any provision in the Patriot Act, and only 12 of those allegations warranted further investigations for civil liberties issues unrelated to the Patriot Act. We will have two panels of witnesses today for the hearing. Our witnesses will be discussing why the Patriot Act should be renewed and what, if any, modifications should be considered. For the first panel, we welcome the Deputy Attorney General of the United States, the Honorable Jim Comey. Good morning. The second panel includes outside experts, and I'll introduce them when they come forward. I'd like to thank all of you for being here, and I'd like to recognize our ranking member, Ms. Harman, for her opening statement.
Thank you, Mr. Chairman, and welcome to our witnesses. I appreciate that Mr. Comey, who briefed our committee last week, is here again today. He will be leaving the Justice Department this summer after dedicated service to this country. Also want to thank the witnesses for the subsequent panel, Jim Dempsey, Tim Edgar, Richard Seaman, and Viet Din, for appearing today. It was very important to many of us that we have a second panel so that we could hear outside commentary on the how well the Patriot Act has worked, and I thank you, Mr. Chairman, for adding a second panel, something that did not happen when the Senate held hearings on the Patriot Act a couple of weeks ago. As you pointed out, Mr. Chairman, most of the committee's work on the Foreign Intelligence Surveillance Act, FISA, will necessarily be behind closed doors. But the Patriot Act is a public law. I'm hopeful that this public hearing can help foster a thoughtful public dialogue about how to give law enforcement and intelligence officers the powers they truly need to stop terrorists, but to do so without compromising our cherished civil liberties. The Patriot Act gave us many vital tools in the fight against terrorism. It modernized legal authorities that predated the age of cell phones and the Internet. I voted for the Patriot Act because we need stronger, more robust authorities against terrorists, since it is those terrorists who themselves use electronic communications to raise money and coordinate their operations to harm us. In other words, as I've often said, They're already digital. We need to go digital in the fight against them. But let's recall the context in which the Patriot Act was passed. The bill came to the floor just 7 weeks after September 11, 2001. We were bracing for more attacks. The Senate was closed because of the anthrax scare. We were at war in Afghanistan. Given that atmosphere, I think we did a decent job on the Patriot Act, and we inserted sunset clauses to many controversial provisions to enable us to reassess their effectiveness in 4 years. 4 years have now passed, and no one should have expected us at the time, 7 weeks after September 11, to strike the perfect balance, and we didn't. Now it is time to do better by clarifying our intent and fine-tuning the authorities. Let me offer 3 examples. First, Section 215, the so-called library provision, allows the Justice Department, with a court order, to obtain any records or, quote, tangible things under FISA. This has caused concern that the government would go on secret fishing expeditions for medical records, bookstore records, or library records, something which it has not done, but which the law, as currently crafted, might allow. Terrorists might use the Internet at a public library. Some undoubtedly have. So exempting library records totally could create a loophole that terrorists could exploit. The issue isn't whether we should go after terrorists' Internet records. Of course we should. The issue is what standards should we add to the law to make clear that we do not condone fishing expeditions against innocent or lawful activity. One change that appeals to me is to require that the records sought under 215 pertain to an agent of a foreign power, the traditional standard for FISA searches. Without this requirement, Section 215 is open-ended and susceptible to abuse. Requiring the agent of a foreign power standard would not compromise any investigations of terrorists who are already defined by law as agents of a foreign power. Second, Section 206 allows John Doe roving wiretaps under FISA, where neither the identity nor the location of the target is known. I believe we should retain authority for John Doe roving wiretaps, but we should require the government to ascertain that the target of the surveillance uses the communications device, even if we don't know his name, before beginning the wiretap. This would make FISA consistent with the Title III criminal wiretap standards and avoid generalized surveillance of all people fitting certain ethnic descriptions. Third, Section 218 allows FISA search and surveillance whenever foreign intelligence collection is a significant purpose of the investigation. It no longer needs to be the primary purpose. I think this is a useful provision. It helps to eliminate that mythical wall, as the chairman mentioned, between law enforcement and intelligence. But it could easily be abused because the standard for FISA is much lower than the probable cause standard for criminal authorities. I would retain this provision, but I would require that U.S. persons, I'm just talking about U.S. persons, who were the target of a FISA search, which failed to turn up evidence against them, be told after the fact that they were searched, after an appropriate amount of time has elapsed so that any ongoing investigation is not compromised. According to press reports, Brandon Mayfield, the Muslim American attorney in Oregon, who was wrongly arrested and imprisoned on suspicion that he was connected to the Madrid train bombings, was not told that the government conducted secret surveillance on him and his family, even though it's now clear that he, a U.S. person, is innocent. These are not partisan issues, Mr. Chairman. 71 members of this House from both sides of the aisle have co-sponsored the SAFE Act, which would make many of these narrow fixes to the Patriot Act. I hope our witnesses will comment on them. The terrorists would like nothing more than to take our liberty and expose it as a fraud, Mr. Chairman. But it is not a fraud. It's the most important value we have. And I believe that in considering the Patriot Act, the most patriotic act we could, as members of Congress, do would be to keep the vital authorities to go after terrorists, but to ensure that we are also protecting the privacy and liberty of the American people. Thank you, Mr. Chairman.
Thank you very much. Mr. Comey, welcome, and your entire statement will be submitted for the record, as it will for all the other witnesses. Feel free to go through as much of it or as little as you would like in your testimony. Mr. Comey, thank you.
Thank you, Mr. Chairman. Ms. Harman, members of the committee, thank you first for inviting me here today. Thank you for caring so passionately about these issues and for offering an opportunity for a robust discussion of the details of the Patriot Act and what they mean and why they matter. Everyone should question government power. Our country was founded, as the students in this room I hope know, by people who had a real problem with government power and worried about government power, divided our power, restricted our power, provided for checks and balances of government power. People should question government power. They should demand the details about how government is using its power. We in government should explain how we're using our power. If we can't explain ourselves and how we're using our tools in an open forum or, if appropriate, in a classified form, if we can't explain, we shouldn't be using those tools. We shouldn't have those tools. That's our duty. My worry about the Patriot Act over the last 3.5 years was that we were never going to find the space in American life to actually have a reasoned discussion about the Patriot Act and those tools, where those who had concerns asked the good questions and those in government took the opportunity to explain why it matters. I saw instead an exchange of bumper stickers that worried me very much, and people standing around at barbecues or cocktail parties, and someone in the circle says, "Isn't the Patriot Act awful?" And everybody nods and then talks about the baseball game that weekend. Or people in government not wanting to answer fully the questions being asked of them because they were busy doing other things or because of concerns about giving too much information. I worried we wouldn't find that space. Thanks to Congress and this committee in particular, we have found that space. Despite my skepticism, over the last couple of months, we have had dozens of meetings, of discussions, of hearings, of witnesses in open forums as much as possible and in closed forums to talk about some of the details of how we use our classified tools. I think we have found in that space the opportunity for the questions to be asked, the details to be demanded, and for them to be supplied. I think we have seen in that space that the Patriot Act is smart, it's ordinary, it's reasonable, it's constitutional, and we've had a robust discussion that has given, to me, great heart in what oversight is by this body and how responsible our government on the executive branch side can be in responding. So thank you for that. We have somehow found the space to talk about things like delayed notice search warrants, so-called sneak and peek search warrants, something that I, as a career federal prosecutor and assistant U.S. attorney in New York, then in Virginia, then U.S. attorney in New York, and now deputy attorney general, a term with which I'm unfamiliar, sneak and peek. It's not a term that we in law enforcement use. That may be because it makes it sound like we're going through your sock drawer while you're taking a nap. We call it delayed notice search warrants. We have found the space to explain what that is to folks. An example that we've given quite often, and I think people have heard, is we used it recently to disrupt a huge ecstasy trafficking ring that was bringing in huge amounts of pills from Canada to the United States and selling them to our kids. We were on the verge of locking up about 170 of these characters for drug trafficking, and we learned that a big load was coming across the Canadian border into upstate New York, and we had a difficult choice to make. Whether to seize the drugs and alert the 170 that we were onto them, or let these drugs walk to the kids of the United States. We've explained in the last couple of months that we didn't have to make that choice because we had delayed notice search warrants in the Patriot Act, in black letter law, something that had existed for decades before then. And we used that provision, went to a federal judge and got permission, based on a showing of probable cause, to seize those drugs and not tell the drug dealer that we had taken them. So the DEA did just that when this drug courier stopped to get a bite to eat. They stole his car, didn't steal it. They took it pursuant to a search warrant and sprinkled broken glass in the parking lot so that he thought it was stolen. And we found in a false gas tank some 30,000 tablets of ecstasy. And we didn't tell him for about 3 weeks, when we locked him and the other 170 up and made an enormous impact on the ecstasy market in the United States, dropping the bottom out of the price and supply of ecstasy. That's a delayed notice search. I worried that people would never understand that. I think folks now do and understand why it matters so much to us. We in the executive branch believe the bottom line on the Patriot is, as I said, the Patriot Act. It's smart, it's ordinary, it's constitutional, it makes sense, and it's chock full of oversight. My life has involved federal judges. Federal judges are all through the Patriot Act, in the FISA process, in delayed notice search warrants, in just about everything we want to do involving the Patriot Act involves judicial oversight and also congressional oversight. We spend a lot of time, as we should, sending reports to this committee, to your Senate counterpart, to House Judiciary, Senate Judiciary, to explain ourselves, as we should. And we spend a lot of time answering to our Inspector General, who was given a mandate by Section 1001 of the Patriot Act to scrub us on a regular basis and to answer, respond to, investigate all complaints about the Patriot Act that he receives. The Patriot Act should be renewed. Oversight should continue. The questions should continue to be asked. We should continue to explain ourselves. But these tools are too smart, too important to our national security not to have them renewed. And I look forward to discussing why they matter so much to us with this committee. Thank you, Mr. Chairman.
Thank you very much. Mr. LaHood.
Thank you. Thank you for your service, sir. We appreciate all of your service, particularly when you were a U.S. attorney and certainly in your work now. We had a very enlightening discussion with the director of the FBI that was not public, and can you, on the record and for the public, tell us the 2 or 3 things, and maybe I'm sure there's more than 2 or 3, but tell us 2 or 3 things where the Patriot Act has really benefited law enforcement in terms of their ability to keep the country safe and to keep communities safe. And then if you would also tell the public and on the record, are you recommending any major reforms or changes to the Patriot Act as a result of abuses that may have taken place?
Thank you, sir. The Patriot Act did something that was groundbreaking, earth-shattering, breathtaking for my world that we don't talk about an awful lot, but I believe Congresswoman Harman alluded to. It destroyed once and for all the wall, which was a combination of law and lore that separated criminal investigators from intelligence investigators chasing terrorists. Before the Patriot Act, we had a situation where my good friend Pat Fitzgerald, the U.S. Attorney now in Chicago, was the leading al-Qaeda expert on the criminal side in the Justice Department, and he was leading a group of agents investigating Osama bin Laden and al-Qaeda in the 1990s. In the process of doing that work, he was talking to cops, talking to foreign witnesses, civilian witnesses, talking to foreign intelligence officers, even talking to al-Qaeda members who had come in from the dark side and become cooperators. There was only one group that he couldn't talk to, and that was the group of FBI agents following the exact same targets, Osama bin Laden and al-Qaeda, from the intelligence side, across the street, conducting surveillance, talking to witnesses, getting FISA authorities to intercept communications or do searches. So we had 2 of our best brains focused on our worst enemy, and they couldn't speak to each other. What the Patriot Act accomplished was the destruction of that wall that had grown up over the years and allowed those 2 groups to talk to each other. That has made us safe in ways that my words can't capture. That has changed the culture of law enforcement and intelligence in the United States and allowed us, as we did, one example as recently as last year, when we were tracking an al-Qaeda operative who had come into the United States, to make sure that our criminal prosecutors were talking to us about what they could do to incapacitate the guy, while our intelligence operators were gathering information on him. And when the moment was right, we could turn to our criminal prosecutors and say, go, incapacitate him, lock him up. And that was done. That changed our world, and I don't think anybody who is focused on what this provision means wants to go back on it, because it has made us immeasurably safer. We I don't believe that we have advocated any changes as a response to abuses. I don't believe there have been abuses of the Patriot Act. And we have an Inspector General, Glenn Fine, who is as good and aggressive as they come, and he hasn't found any either. What he's found instead is that folks write in and call in about all manner of things that have nothing to do with the Patriot Act. Because as everyone here knows, the Patriot Act has become a bit of a vessel into which people pour concerns about a whole lot of stuff that's not in the Patriot Act. We have suggested through the Attorney General's testimony that we respond to some of the concerns that Ms. Harman raised with respect to the so-called library provision, which I would love to talk about later because I've never figured out why it's called the library provision, but to address concerns about whether people can challenge in court in order to produce records that they get under that provision, consult with a lawyer, and address concerns that there's no express standard for obtaining these documents, this court order to obtain documents, in that section. So as the Attorney General said, we have no problem and would support putting an express relevant standard there and making it explicit that folks who have concerns about an order they've received can consult a lawyer and challenge it in court. We have a couple other minor things that we think would improve the Patriot Act, but again, not in response to abuses. Our response to the concerns about abuses is to talk about how we're using the tools and why we think folks with good intentions, we're not questioning anybody's motives, but that they don't quite understand either how we're using the tools or how these tools compare to what criminal investigators do all day long in the United States.
Well, the reason it's called the library provision is because the librarians got every member of Congress all stirred up last year when they had descended on Capitol Hill and made it appear that there was going to be an ability for an FBI agent to go into the library, look into computers without the say-so or sign-off of a federal judge or without a... And frankly, during our discussion with the FBI director, he said that isn't the way it works. And he said he didn't know of any instance where the FBI went into a library anywhere in the country to do that. And I think it will be an issue. And, Mr. Chairman, if I could just ask him to talk about that for a minute, elaborate on what I've just said, because the director made it very clear. They don't want to go into libraries if they don't want to. They haven't, but the provision is there in the event they have to. And if you could just discuss that for a minute, my time is up. Thank you very much.
Thank you, sir. I've challenged journalists in I hope a friendly way to try to win the Pulitzer by examining how it came to be associated with libraries, because to a prosecutor or investigator, we see books, records, documents. We don't think libraries. We think credit card records, insurance records, travel records, things of that sort. But I think all of us start, I hope, from the premise that we don't want libraries, as Congresswoman Harman said, to be any kind of sanctuary for criminal behavior. We know, unfortunately, that pedophiles go into our libraries, fraudsters go into our libraries, terrorists go into our libraries. As my former colleague, Chris Wray, from Assistant Attorney General in charge of criminal, said, or one of the U.S. attorneys a couple weeks ago, there's reason to believe that the 9/11 hijackers were using libraries. So none of us want to have a place where terrorists or criminals feel safe to go. So the question then should be, what's reasonable? And I think that that Section 215, the so-called library provision, is a reasonable approach to obtaining records that would be at a credit card agency or a library, conceivably, although it's never happened, that relate to an international terrorism investigation. I think a lot of the concern about this provision rests on a misunderstanding about how we obtain records in the criminal world of investigations with a grand jury subpoena. This provision that folks are so concerned about offers more oversight from a court and from Congress, infinitely more in my experience, than similar process to obtain records on the criminal side. An FBI agent has to go to a federal judge appointed by the President, confirmed by the Senate, who sits on the Foreign Intelligence Surveillance Court, and make a written application where he certifies that the records are sought for an international terrorism investigation, and get a written court order from a federal judge to get those records. We then report to Congress how we've used it every 6 months, what we've used it for, whether the request was denied or granted. On the criminal side, an AUSA, and I've done it hundreds of times, issues a subpoena, conceivably for library records, which we did to try and make the case against the Unabomber, Ted Kaczynski, with no involvement of a federal judge, no reporting to Congress, no written application, and obtains those because they're relevant to a criminal investigation. So I think if folks really bore down, what they'll see is the Patriot Act actually made it harder for people tracking the most dangerous of our enemies to obtain the records that could be obtained by a criminal investigator much, much more easily with much less oversight.
Ms. Harman.
Thank you, Mr. Chairman. Mr. Comey, I appreciated your opening remarks, especially your very positive comments about the importance of oversight. We have, as I hope you know, established an oversight subcommittee in this committee, and it is vigorous and at work, and we have excellent members and excellent staff on that committee. I'm very proud of it, and I appreciate the fact that we have done that in this Congress. It's a first. Let me agree with you about oversight. Let me also applaud you for some of the things you just said about Section 215. As you know, in my opening comments, I pointed out that you need a court order to use Section 215. I pointed out that, according to the Justice Department, it has not been used to search library records. I also said that if we would repeal 215 totally, we would create a loophole which the terrorists could exploit. So I do understand that terrorists and other bad guys can go to libraries and use internet sites. But I said, and I think I just heard you say, that some reasonable additional limits on it to make clear to the public that we will not use it for fishing expeditions might be a good idea. You just mentioned two, and I would like you to perhaps explain them in more detail. I have the curse or the blessing to be a lawyer, so I was listening up. You said there will be an express relevance standard, and you also said that there would be some clarity on the notion that someone subject to a 215 search could consult a lawyer. So my question is, I suggested a relevance standard, which is that the target is an agent of a foreign power. You suggested a different one, I think, which is that the search relates to an international terrorist investigation. Could you explain where you're going with this? And the second deal is on consulting with a lawyer. Could you give us some clarity on what this means? Does the lawyer have to have a security clearance? How could a lawyer challenge the search? Through the FISA court only, through the federal courts? What would be the process here? And I would just point out that the person we're talking about is not the terrorist. We're talking about the person who controls the records, the librarian or the bank director or wherever you might be going. So nobody is in favor of giving terrorists special powers here. We're talking about law-abiding American citizens and the public having some assurance that 215 is really intended to be what I think it's intended to be, which is an additional tool only to go after bad guys and prevent and disrupt their plans to attack us.
Okay. Thank you, Ms. Harman. The proposal to change 215 to require that the records sought, as I've understood it, is that the person whose records are sought is a person, a target who is believed to be an agent of a foreign power. My concern with that is that I think it would restrict the utility of 215 in real-life investigations. And the example that I've thought of is, imagine Mohammed Atta's roommate. And if we have 215 with the standard that the target whose records are sought is an agent of a foreign power, if I imagine how I would conduct an investigation of Mohammed Atta's roommate, I know what I would do. If I knew a guy lived with Mohammed Atta, I would want his travel records, his bank records, his phone records, and if I found out that he'd gone to Las Vegas, for example, I would want those hotel records. I would want the video of every place he'd been inside the casino. I'd want to know where he ate his meals, all that sort of thing. As currently structured, the FBI could use 215 to get Mohammed Atta's roommate's phone records, travel records, and the records of his hotel in Las Vegas. What I worry about is that if you added the target is an agent of a foreign power requirement, or as some have proposed, something higher like probable cause, we can't use 215 for that, because I don't know anything about this guy except that he was living with Mohammed Atta. But I know that I want to know.
Wouldn't Atta, though, be an agent of a foreign power, and a fellow living with an agent of a foreign power? Wouldn't that qualify if we had a definition of related to an agent of a foreign power?
Perhaps that might, if it said that the records relate to an investigation of someone who is a target of a foreign power. I don't know, though, that that would be any different from what we have now, which is sought for an international terrorism investigation, because we investigate people, and so currently we are investigating someone we believe to be an agent of a foreign power. What I worry about is anything that would require or limit the ability to investigate people around the bad guy. Someone we saw having breakfast with someone we know to be a terrorist. We need to know what's up with that guy. And if we can't use 215, I tell you what's going to happen. We're going to find out because we think it's our duty. Agents will try and find a way to go to criminal process and get a grand jury subpoena, which, as I've said to folks out of government who've questioned 215, the effect of that, ironically, would be to drive the FBI from a world that involves judicial oversight and congressional oversight into the grand jury world, which has none of that. And so what I would prefer to do is just address the concerns of 215 that you highlighted, let people talk to a lawyer, have a procedure for being able to go to the FISA court. I think that makes sense because they would have issued the process, and challenge it, perhaps as you could a grand jury subpoena for being overbroad, unduly burdensome, things like that. I haven't thought it out carefully enough, but to allow people meaningful access to the judge that issued it to challenge it.
Well, my time has expired, Mr. Chairman. I just want to comment on the response. I think we're moving in the right direction. Certainly the challenge piece, when it is fleshed out, will be very positive progress. On the express relevance standard, those are your words, Mr. Comey. I think we need to work on this a little bit more. Sought for is a very vague term. I think something that would be tighter and cover the circle you just described. Mohammed Atta and his contacts, of course, should be covered under the provision. But what we need to do, in my view, is add the right words to give clarity to the intent, which is that this is not a fishing expedition provision. This is a tightly worded provision requiring a court order, including the ability to challenge, that enables us to use modern tools to find the bad guys who are using digital means to evade us. Thank you, Mr. Chairman.
I have not been cursed with becoming a lawyer. And I know I don't. I'm glad you admitted it. And this is a very difficult issue because I know that in discussions that we've had with our European counterparts, the issue that they are increasingly becoming concerned about is the radicalization of individuals within their society who are second and third generations native in that country and are becoming radicalized. And the example that they've used in the Netherlands is the individual who murdered Van Gogh, or is alleged to have murdered Van Gogh. And also individuals or groups that may have threatened a number of their members of parliament, which is requiring 24-hour surveillance and protection. So, and I think it'd be hard under certain circumstances to define that individual or those individuals who maybe share some of the same objectives as terrorists, but as identifying them as agents of foreign powers. So, we look forward to working through this process with you. Ms. Davis.
Thank you, Mr. Chairman. I'm not a lawyer, and I know one of the biggest issues that I've heard from my district has been on the so-called library section that we've been discussing, and I guess I just want to make sure I understand it. From what I heard from you, with the Patriot Act, you can go in and you go before the judge and get permission to go in and check the records. There's also congressional oversight every 6 months. But if I heard you right, you have this authority in a criminal investigation, right? And you don't have to go before a judge, and you don't have congressional oversight. So explain to me why there's a concern. I mean, I guess I'm having trouble understanding what freedoms have we had taken away by the library clause in the Patriot Act that already weren't taken away if we were in a criminal investigation. I mean, I guess I'm confused on that.
And thank you. I share the confusion, and I think it's just a question of folks not understanding what goes on hundreds of times a day in our criminal process. Federal grand jury subpoenas issue by an assistant U.S. attorney acting on behalf of the grand jury issuing them. They're issued on a relevance standard. They don't require approval by a judge. They don't obviously require, in fact, Rule 6, grand jury secrecy prohibits disclosure in the form of oversight. What 215 did was give intelligence investigators and counterterrorism investigators the ability to do something similar to get documents, but made it harder. As you pointed out, you had to go to a judge, you had to make a written application. The one thing that 215 offered that folks often focus on is every court order carries with it a prohibition on disclosure. So a credit card company that gets a 215 order for documents issued by the FISA court in connection with an intelligence or international terrorism investigation can't tell anyone that they received it. Can't tell the target, for example. Or, as I've heard said many times, a library couldn't tell its patron that his records were obtained pursuant to this court order.
Could they in a criminal investigation?
Maybe. Thousands of times a month, we issue grand jury subpoenas to financial institutions to investigate fraud, to investigate all manner of things. All of those carry with them a statutory ban on disclosure. So if a bank receives a federal grand jury subpoena in a bank fraud investigation, they can't tell anyone that they got it. That surprises a lot of people, but it's been the law for over a decade. And the reason I explain it to people is so they see this is a part of the American way of investigating. There are good reasons for it, so that innocent people don't get smeared, and so the bad guys don't get away. In the counterintelligence and counterterrorism arena, it's hard to imagine higher stakes in terms of the bad guys getting away, or frankly concerns about smearing people. What I have said to librarians who've asked me about this, I've said, look, you care about civil liberties, obviously you do, and that's why you're asking these good questions. If you do, then you wouldn't want the FBI telling anyone who they're investigating or why. You wouldn't want them walking into the library saying, we're checking out Jim Comey, we got an anonymous letter that he's a terrorist. You keep that to yourself, but we've got a court order to get these records. You wouldn't want us doing that. So by definition, you won't have the information about the investigation. So why is it you should make the call about whether to tip off the target? What people, I hope will take some comfort in is if we add the opportunity to challenge in court, to go to a judge and say this is wrong, that will give them some comfort that they're not forever having their mouths sealed. But secrecy in investigations is critical in the criminal context. It's as critical in the intelligence context and counterterrorism. We get many, many emails and calls where neighbors or spurned lovers identify people as would-be terrorists. We have to check those out. I mean, that's our job. But if we check them out in a way we're sort of rumbling around like a big elephant and tell the whole world that the FBI is conducting an investigation of Jim Comey, I think if people tease that out, they don't want that to happen. So I think if people understand how we do criminal investigations, they will see that this provision, the so-called library provision, carries with it more oversight than anybody gets on the criminal side.
And you're talking about adding the challenge to the library provision. Is that challenge available in the criminal investigation?
Yes, someone who receives a federal grand jury subpoena can challenge it as overly broad, unduly burdensome, and that happens from time to time. And so what we would do, I think the idea the Attorney General was talking about was taking that sort of ability to move to quash, as the lawyers call it, and sticking that in the 215 provision.
Thank you, Mr. Comey. Thank you, Mr. Chairman.
Ms. Eshoo.
Good morning, everyone. First of all, Mr. Chairman, thank you for holding this public hearing. So many of our meetings are not public by necessity, but I think that this goes a long way to informing, to educating the American people who with legitimacy have raised questions. I think all of our constituents have raised some kind of question, or many, as may be the case, about the Patriot Act. So thank you for holding this hearing. I think it's, again, very important, and I think that it will go a long way with the American public. Thank you for being here, and thank you for your public service. I'd like to raise a broad issue that has been attached to the Patriot Act, but I think many, many Americans have found really disturbing. After September 11th, the government rounded up illegal immigrants and put hundreds with no ties to terrorism behind bars for months, often in deplorable conditions. The Justice Department's own Inspector General found that the government made little attempt to distinguish people with ties to terrorism from those without. In conducting this roundup, the administration gave itself far more power than the Patriot Act does. Under the Act, aliens are to be held no more than 7 days before immigration or criminal charges are brought. This runs contrary to what the American people believe is a justice system. And if there's anything in emerging democracies that is measured very, very carefully, is how a justice system and courts and laws are actually built, the architecture of that. So my question to you is, you either have the stuff for deportation after a given period of time. I'm not saying a day or two, but an appropriate amount of time. And at some point, you either have the stuff to charge someone or to deport them. So, and I think that that the abuse of the Patriot Act, so to speak, is spoken to in this case. So what is the authority, in your view, under the Patriot Act that allows what I described? I know that the sections are 411 and 412, I believe, but I'd like you to set for the record what is contained in the Patriot Act that allows what I described, which is horrific. I don't know one person, whether they're for the Patriot Act, whether they're left, right, center, whatever, that says that this is really acceptable, that it's a wonderful standard that the American people uphold. It just does not speak to our values.
That is a fair criticism. That is not the Patriot Act. That was what I believe, a legitimate investigative approach that went awry and that the Justice Department did not handle correctly. Our Inspector General has found, and I agree with him, that it was legitimate for FBI agents conducting the 9/11 investigation if they came across a roommate of one of the hijackers or someone they just had a really bad feeling about and found out that they were violating the immigration laws, they were out of status, to take them into custody. I don't think anyone...
I'm not talking about just taking people into custody that are suspects. That's the work of law enforcement. But the abuses that I described, I wanted you, for the record, to set down, if there's anything that you find defensible about that, to state for the record what the Patriot Act contains in order for the, for our government to be doing that. Has it completely stopped? Has everyone that was detained either been deported or charges brought against them?
Well, as I was saying, I think that the initial arrests of people who were violating the immigration laws was appropriate. Where it became inappropriate was, as our Inspector General found, when they were, and I think this is what you're alluding to, when people were held without being appropriately cleared, they were held until cleared, they were held far too long, and some people were mistreated, physically mistreated, at detention facilities, particularly in Brooklyn, New York. No excuse for that, unacceptable. Your sentiments are exactly mine. Not what the American people want done. The first step, I think the American people want done. The rest is totally...
Is there anything in the Patriot Act that needs to be repaired, in your view, so that that abuse doesn't take place?
No.
No.
That abuse, both the appropriate part and the part that was wholly inappropriate, had nothing to do with the Patriot Act. Those were arrests of people who were out of status, violating the immigration laws. I'm no expert in immigration, and so I will now stray beyond my expertise. But the Patriot Act doesn't deal with that. The Patriot Act has some very specific...
Was it an interpretation of the Patriot Act that allowed that to happen?
No. In fact, most of those arrests went on before the Patriot Act was enacted. The real intense period was the 2 weeks, as it should have been, right after 9/11. Patriot Act wasn't even in existence.
Are all those detainees now either deported or charged?
I don't know the answer to that. I assume that they are. I don't know whether any of them are still tied up in litigation seeking asylum, for example. That often takes a long time.
Well, charged or deported, but not just being detained.
Oh, I'm quite confident that none of the people that you're talking about are still in a state of limbo. Each of their cases was examined by our Inspector General. And as I said, what he found was not pretty for the way that they had been handled.
That's why I raise it.
Yeah.
Thank you, Mr. Chairman.
Ms. Wilson.
Thank you, Mr. Chairman. Mr. Comey, thank you for being here. I think some of the answers to questions that we've been hearing from you are very helpful in clearing up misconceptions about this act. And there were a couple of things I wanted to ask you about. The first one is actually a follow-up to what my colleague from California, Mrs. Eshu, just mentioned. She mentioned Section 412 of the Patriot Act, and as you've just clarified, that was not the statute where there was a problem with detentions. Has Section 412 ever been used by the Attorney General?
No, if I'm remembering the numbers
I'm sorry.
right, 412, I believe, is the provision that allows the Attorney General to order the detention of someone as a specially designated terrorist.
Yes.
And that has never been used.
So we've never even had a case where the statute has been used.
My understanding is it's not been necessary because the government has been able to convince immigration judges that someone should be detained as a danger to the United States without the Attorney General having to invoke this extraordinary authority, which, believe me, I'm not advocating taking it off the books. When you need it, you would really need it. But it has not been necessary so far, thank goodness.
Let me ask you a question about, you were talking about additional provisions on Section 215, the so-called library provision or business records. And you talked about all of the checks and balances that are in place with respect to potential terrorists in Section 215, but also adding a relevant standard and some other things. Why would we want to give more protection to potential terrorists than we give to members of the mob under criminal statute? Why do we want to tighten this up? I don't understand that.
Well, I don't know that we want to offer them more protection. I hope I'm not coming out for more protection for them than for people in the mob. But I think we have always understood Section 215 to have a relevant standard in it. I mean, we don't want the authority to seek things that aren't relevant. I mean, we hope we're not spending the tax dollars that way. So we don't think that changes the way we approach it. What we think it does is offers folks comfort that that is the standard. To the extent they're worried that we're out there doing things with...
So it's just for reassurance to people because of all the misconception? Is that...
I think that's a fair way to say it, and to make it consistent, as we've always understood it to be, with our practice in seeking documents under grand jury subpoena authority. The ability to challenge the receipt of a 215 order, I don't know that I see that as offering more protection for terrorist bad guys or spies. I think it offers legitimate businesses who are receiving these the opportunity, if for some reason they think it's overbroad or unduly burdensome, to come to court to raise that concern. I don't think that will have any effect on our ability to do our jobs.
Are there advantages to having Section 215 authority with the FISA court over going to a grand jury, or is this something that, what's the path of least resistance if you're an FBI agent trying to investigate a bad guy?
The path of least resistance is most likely to go the criminal route if you can, and if a federal prosecutor is available to you. There may be cases where there isn't a particular criminal hook, as we say in the business, where, for example, you're investigating an agent of a foreign power not in a terrorist environment. So maybe it's an espionage kind of thing, and it's not in a position yet to go to a criminal prosecutor and say there's a predicate here for potential criminal wrongdoing. That's one circumstance. The other is that it's a circumstance where, because of time pressures or the location of a particular effort, you don't have the opportunity to go to a federal prosecutor and get them to open a file and get a grand jury subpoena cut. I shouldn't make it sound so easy to get a grand jury subpoena. There are plenty of places where there's not a grand jury sitting. I tend to come from the big districts where there's always a grand jury sitting, but there are plenty of places in the country where the grand juries only come once a month, so it may be harder to get a subpoena in that environment.
Let me ask you about the so-called sneak and peek provision, Section 213. Can you talk a little bit about how warrants like that are used on the criminal side? And because I think initially this was something of a surprise to people. I wonder if you could give us some examples of where that has long been used in the criminal system, and why you think that it's helpful to apply that to potential terrorists.
Yes, I'd love to. This is something I feel very passionately about, because this is a tool that was created by judges. Republican judges, Democratic judges, independent judges, who concluded that it was reasonable under the Fourth Amendment, which is the key standard under the Fourth Amendment, in certain unusual circumstances to delay telling someone that a search was conducted. It's never the case that you're never telling them. It's just for certain emergency circumstances, delaying that notice. We don't do it much. We've done it since before I was born because judges created this ability to delay notice. We do it, we've calculated now, in about 1 out of every 500 cases in the United States. I've done it typically in cases where lives are in jeopardy. I did it in a drug case in Richmond, Virginia, where we had a group of really bad crack dealers moving in from New York, and we had an informant who came to us, reliable track record, who said they just put 5 kilos of cocaine in an apartment in the West End of Richmond. And we had a difficult choice to make without delayed notice, because we had to choose between going and getting the 5 kilos and heating up all these bad guys and jeopardizing the informant's life, or letting 5 kilos of cocaine walk onto the streets of Richmond. Instead, because the Fourth Circuit had long ago created delayed notice search warrants, we went to a federal judge, laid out in much more eloquent fashion what I just said, and made a written showing of probable cause based on a sworn DEA affidavit. The judge then gave us permission, written order, to conduct the search in that apartment for the drugs and to make it look like a burglary. So the DEA went there. They entered the apartment when the bad guys weren't there. They found the 5 kilos. They took those. They took the TV, the stereo, and in a sort of a flare of theatrics, they took 3 beers and poured them down the sink and set them around. Then they broke the window from the outside, I'm pleased to report, in, and then they left. And the 2 leaders of the drug organization came and called the cops. And so we sent a marked unit, briefed officer from the Henrico County Police Department, and he took a report from these 2 knuckleheads about that their TV was stolen, that their stereo was stolen, and that their beer had been drunk by these burglars. And nothing else was taken, officer. No, nothing else was taken. Can I see your license? Can I see your license? Full identifiers on these characters. It's your apartment? Yes. Okay, we'll investigate. And I don't remember whether it was 45 days or 60 days, but after a brief period of time, we arrested not only these 2 guys, but their whole organization, unsealed the search warrant, told them we had been there, offered to return everything except the drugs, and nobody wanted anything back, and then the DEA paid to fix the window. That's a delayed notice search. Judges created it because, as I hope my story demonstrates, we got to have that authority. And agents all over this country have used it for years and years. What the Patriot Act did was take that judicially created tool and put it in black letter law so the whole country has the same standard, and it's all laid out there what a judge has to find. We can't lose that tool. We just can't. And sometimes people say to me, well, geez, you're using it. That's not a terrorism case you just described. My response is absolutely not. And the Patriot Act was primarily a counterterrorism tool. But your federal prosecutors and FBI agents and DEA agents are out there in the field. When they're going through the code book looking for something to keep people safe, they don't see something that says Patriot Act, do not use if the lives only involve drug cases. They're using these tools in where it makes sense. And I think it's incumbent upon us, if we're going to debate it, not to do a distraction play and say, oh, that's not a terrorism use. Absolutely. Let's discuss whether that use makes sense. If people don't think it makes sense, then they should advocate its repeal. I think it makes tremendous sense and saves lives.
Mr. Ruppersberger.
I think, first, I want to thank you for your testimony, and I'm sorry we're going to lose your professionalism wherever you're going to go. But first, I think one of the issues that I think is extremely important in dealing with the Patriot Act is the sunset provision. The fact that we had to move quickly right after 9/11 was something that we had to do, and that's why we have some of the issues that we're debating today. But I think that the sunset provision, every year, every 2 years, that would allow Congress to look to see whether there are abuses, is that check and balance that we would seek. What's your opinion about having a sunset on the Patriot Act on a every 2-year basis?
My concern about it, Congressman, is that I think that if we have vigorous oversight, if we continue to report every 6 months, if we're hauled up here and grilled and explain in a classified setting, unclassified setting, what are you guys doing and how is it working, I don't think we need sunsets if we have that. My concern about additional sunsets is, I mentioned 218, which changed my world by allowing criminal and intelligence to communicate. If we put a sort of a timer on that, a kitchen timer on it, it's going to expire. that will impede the cultural change that I see going on now. Same with some of these other tools. If agents and prosecutors don't think these things are permanent, they're going to hesitate to embrace, especially some of the cultural changes that we see. I mean, I'm not saying it's an unreasonable thing to say. I just don't think it's necessary, and I don't think it's any substitute for the kind of oversight that this committee does. I think all committees in Congress should have that kind of oversight. Find out what we're doing, ask those questions, but I worry that we will chill the use of some of these tools if we say to FBI agents, look, you can use them, but that might go away in 2 years, and you might get your rear end.
But isn't this a mechanism to seek the balance? There's no question that we need to protect our national security and our citizens, and that we need to be aggressive and give the tools. But it's the balance that we're talking about. And I want to point out, because I think it's important that we look at examples now. The Justice Department Inspector General, I believe, has received 7,000 complaints of civil rights violations by federal officials, but only one investigation pertains to the FBI's use of the Patriot Act. Is that correct?
Yes.
That's astonishing to me, that would be only one. Now, of the complaints received from October 2001 to December 2004, the Inspector General said nearly 4,000 did not warrant investigation, and that more than 2,000 complaints were against agencies outside the Justice Department, and fewer than 1,000 fell within the Justice Department's jurisdiction, but were mostly managerial. Now, that of all the issues, there was only one complaint that had a basis to proceed. Could you explain that?
And my understanding is that, before I get to what I think the one case is, I think that's a function of...
And I'm going to get to that case, Brandon Mayfield. Okay.
Right. Then I'll wait. I'll just say, generally, I think that demonstrates what I hope people are realizing through the kind of discussion we're having here. The Patriot Act has become this vessel into which people pour concerns about things unrelated to it. The Patriot Act is a bunch of fairly small stuff, upgrading for the digital age, giving tools that we could use on drug dealers who switch cell phones to people chasing spies and terrorists, a whole bunch of stuff like that. A couple of huge things like, well, one in particular, the breaking down of the wall. But it is very smart, very ordinary, and I'm so glad that he's reporting and following up so people see that there may be lots of concerns out there in the country, but they're misplaced if they're focused on this piece of legislation.
Okay, well, let's get to Brandon Mayfield. Now, the Muslim American community are very concerned about the Patriot Act. I've met with numerous groups, and they feel that because of the radical Wahhabism that we all have to be concerned about, that they are put in the same category, and which is not the case. So there are Muslim Americans. In fact, I think it's important for us, this is a diversion from where we are, that Muslim Americans become more aggressive and send the word out that Islam is not about blowing people up. I think that's extremely important. But in the Brendan Mayfield situation, this was a Muslim American, from an attorney from Oregon, and he was wrongly arrested as the facts have determined. He was not told that the government had surveilled he or his family. Now, I'm interested to know what happened and what went wrong in that case so that we can evaluate what went wrong, to see whether we do need to tweak this Patriot Act to make sure that we balance the civil liberties versus giving the tools to the investigators and the prosecutors and the FBI. Could you please explain that case?
Yes. As am I, Congressman, and our Inspector General is conducting an investigation right now of how the FBI conducted itself in that investigation, particularly focusing on how they came to misidentify this guy's fingerprint and to say it was a fingerprint found on a bag in the bomber's car parked at a Spanish train station. And then separately, we're also looking at how our prosecutors conducted themselves.
But I'm more interested in how they conducted themselves in their reliance on the Patriot Act, so that we can make sure that we try to protect from those abuses. And sometimes we can't protect abuses if we're trying to stop a terrorist attack. So we understand that also.
And I feel, I'm never one to jump the gun on any investigation, but I feel quite confident that this had nothing to do with the Patriot Act. I know this case pretty well and don't know of any authorities from the Patriot Act that were used in this investigation. I think in the sense that the Patriot Act was the most current definition of the standards to be used in a FISA search, for example, that it could be said that the Patriot Act was used, but in no meaningful sense. I think at the end of the day, this is going to be moved from the column, you know, it's now 1 in 7,000. I think it's going to be 0 in 7,001 on the ledger of our Inspector General. I don't think There may have been screw-ups there, but I don't think they were Patriot Act-related screw-ups.
One other thing, relevancy standard, and I'm glad you said that that's important to have a standard. Now, they're all issues, and was a former prosecutor, so I understand the jargon and the theories we deal with. We have probable cause. We have guilty beyond a reasonable doubt to a moral certainty. We have a lot of issues. How would you define relevant standard as it relates to what you would be willing to recommend as a tweak in the Patriot Act?
How would I define relevance?
Relevant standard. Yeah. What would the definition of relevant standards be, so that the FBI and all those involved would know what that means versus the probable cause versus relevant standard issue?
I think that what we envision is having 215 say that the court must find that the records sought are relevant to an international terrorism investigation. I think in the world of prosecutors and agents and cops, relevance sort of defines itself, which is why I'm stalling while I try and think of how to define relevance. But I think it would be...
Would it be a basis to proceed?
A meaningful, logical connection between the records sought and the subject of the investigation. To guard against the...
But how would that compare to probable cause, then?
Probable cause is, based on the facts and circumstances, the facts and circumstances are such that would lead a person of ordinary prudence to believing that certain facts are true. I think that's higher than relevance. Probable cause, as you know, being a prosecutor, is the standard on which we take Fourth Amendment action. We search, we arrest, we charge people. We start at relevance and work to see if there's probable cause. And so it would go relevance, probable cause, beyond a reasonable doubt. Well, clear and convincing would be the next, then beyond a reasonable doubt. My concern is if you peg the standard for the initial investigation at probable cause, we'll never get started. We'll never be able to look at Muhammad Atta's roommate or the guy who had breakfast with a terrorist because we don't have probable cause to believe he's engaged in terrorism activity. We got a bad feeling, and we believe it's responsible to investigate, and the investigation would be relevant to the international terrorism case. But PC, as we say, probable cause would be way...
And I'm not saying we should use it. I'm just...
Gentleman's time has expired.
Thank you, Mr. Chairman. The standard issue.
All right. Thank you. Mr. McHugh.
Thank you, Mr. Chairman. Mr. Comey, first of all, thank you for your service. Best of luck to you in your future endeavors. We're saddened by your departure, but wish you all the best.
Thank you, sir.
A few of my colleagues have said they're blessed or cursed by either the lack of or the presence of a law degree in education. I don't know where that leaves me. I dropped out of law school after 10 days, so I guess I'm in limbo. But just point of clarification on what Mrs. Wilson in your conversation pointed toward. All other things, as I believe I heard your response, all other things being equal, you have a grand jury available, federal prosecution resources are in line, you would probably try to pursue under the criminal provisions rather than the Patriot Act. Did I understand that correctly?
I think that's the practical reality. If for no other reason than the Patriot Act made it hard for investigators of international terrorism to use its provisions. Okay.
I just wanted to make sure that that was what you were saying. I thought it was pretty clear, but it bared repeating, I think. When you came and were gracious enough to meet with us in closed session, you and I had a bit of a conversation about the criticisms levied against the Patriot Act in broad terms, but probably more so against Section 213 because it's being used for non-terrorism purposes. A couple of my colleagues have brought that up. And I think clearly there is a criminal application. You've attended to that. But let me put an idea out for your response, negatively or positively. What would you be concerned about, if anything, if there were an amendment to Section 213, which I don't believe is expiring? I don't believe 213 was sunsetted here, so we'd have to go in and reopen that provision, which may be problematic to you in and of itself. But if we were to go in and to add a provision, then in those cases where 213 is being utilized, so-called delayed notice, that on the criminal investigation utilization, there is a time period after 2 weeks, 3 weeks, whatever it may be, unless it's thereafter extended. Would that be a especially difficult provision to operate under?
I don't believe it would be especially difficult, to be frank. I don't think it's necessary. the way, and I should have said this earlier, the way 213 works is it now vests with the federal judge the discretion to fix a period that's reasonable. The reason I like that is because the federal judge, whether he's in Southern Illinois or Los Angeles or Dallas, is closest to the facts and is able to make judgments about what's reasonable. We could put in there a provision, as some have suggested, that makes the prosecutor go back every 7 days and re-up. I just don't know why you would do that, and why you would want to sort of have a rote investment of resources when we already have judicial supervision that, and we've reported to Congress on what the average delay has been, what the minimum, what the maximum has been, but each one, again, is supervised by a federal judge who makes that call. It wouldn't be the end of the world, but we have such scarce resources, whatever people may think, on the FBI side and our federal prosecutors or other agents, that I don't know why we would impose that burden on them unless there was a reason, something was broken that we need to fix.
Okay, I thank you for your observation. Let's switch over to 215. One of the criticisms there is that the gag order that is imposed, and you've explained why that is, and I think you've explained it very well, is, at least in some people's minds, unending. And that perhaps there, too, we ought to put into place a 6-month duration unless the FISA court extends it thereafter. I'd be interested in your reaction to that kind of amendment.
Yeah. And I've heard that, and again, I don't think that's a crazy thing to say, but I think given the nature of the investigations in which we use 215 authority, spies, international terrorists, that I think it's more appropriate to strike the balance in favor of having the gag order without duration for a couple of reasons. First, we don't want to let intelligence organizations that may have a continuing presence in the United States know that we've gotten their records. The fight with al-Qaeda, for example, is going to go on indefinitely. And so I don't know that any time period would make sense at which we would want to let a credit card company or hotel clerk call up a person whose records were obtained. I also worry very much about, again, smearing innocent people. I mean, people, I think, sometimes are shocked when I talk about how important secrecy is to our entire system to protect the innocent. I don't know what someone would do with the notice, except perhaps cause mischief for the innocent, those who we've received these poison pen letters on and had to investigate. I've done criminal wiretaps, plenty of them, and there's a provision there that you have to send an inventory notice to anybody who was intercepted. And so I've sent them to dry cleaners and pizza places, or someone who was called to arrange a daycare pickup by a mob boss with kids. And those people, frankly, just get completely freaked out and call you, and you say, well, you were intercepted on a wiretap, and we can't say more than that. Statute requires us to let you know that. So I don't, and maybe I'm not saying it right, I have a hard time picturing what the good citizens of the United States would do with that information, especially when they understood what the nature of the investigation was and why the secrecy mattered so much. We have struck a balance on the criminal side, given the stakes there, in favor of notice in all circumstances at some point. Given the nature of the work on the intel international terrorism side, I think the Patriot Act strikes a reasonable balance.
Thank you. Thank you, Mr. Chairman. My time's expired.
Good, thank you. Mr. Holt.
Thank you, Mr. Chairman. And I thank you, Mr. Comey, for coming today. You know, I try to approach this as most Americans would. Many of us here don't practice law. We just make law on television. And so I'm trying to understand this from the point of view of ordinary citizens. And I think, you know, throughout history, we should remember that throughout history, suspects are by definition suspect. The prosecutors, the investigators, and so forth think bad guys are really bad, unless later they discover that they have the wrong guy. And I realize that in this day of suicide bombing and using airliners as explosive weapons, the consequences of getting it wrong are pretty serious, of failing to identify and intercept potential violent criminals. But we've got to remember, it's also, the consequences are pretty serious of leaving lingering doubts in the minds of millions of Americans that gee, maybe their hospital records got swept up in an overly broad search, or their immigration records got swept up in an overly broad search. It only takes one or two Brandon Mayfield cases to send a chilling effect throughout the country that actually diminishes people's lives. It may not be a bloody massacre like an attack, but it is, it's a cost to our society, and that's why we're so worried about this. And even if there are powers that already exist, as you have said, they may nevertheless need to be examined. And I'm constantly aware at how difficult oversight is to accomplish. And if we don't have the mechanisms built into the law to make that oversight as easy as possible, we're just going to fail to do a lot of things. Because, as important as police power and investigative power is, and it's among the most important powers of government, it's also the most fearsome. So that's why we wrestle with all these. Let me just quickly touch on a couple of points in the little time I have left here. You had said at one point that to us that FISA, the FISA court is not really a rubber stamp. Can you tell me how many FISA applications have been denied in recent years? Choose the time period that you like.
Yes, sir. Last year, none were denied. I think 94, and it may be 74, but either 94 or 74 was substantively modified by the court. The year before, the number of modifications was about the same, as I recall it, and 4 were rejected outright. And so people say to me, we've never had one rejected, and my response to that is, that may seem strange from the outside until you understand the process that we go through before we ever approach the FISA court. It's got to come up, be scrubbed at many, many different levels, including the FBI director, me personally, or the Attorney General personally, before we go to the court. They are federal judges chosen by the Chief Justice of the United States without our input, and they were appointed by all manner of presidents, and they are as tough and independent as federal judges are. They put us through our paces.
Now, should 215 challenges go only to FISA judges, or should any judge be able to deal with that? I mean, is there something special about the FISA court that makes them wiser?
Well, that puts me in a tight spot. They're extremely wise, as are all federal judges. I think it makes sense to go to the FISA court because the orders for documents are first issued by the FISA court. That's where they started. And also they relate to intelligence investigations or international terrorism investigations. Those are areas of significant subject matter expertise demands. The FISA court has that expertise and experience dealing with those investigations and classified information. I don't think it makes sense to go to other federal judges. I'm just trying to imagine a judge in New York getting an application to quash process issued by the FISA court in Washington, of which he or she is not a member. I'm just not sure that would be workable. I think we have 11 judges on the FISA court. They work very hard, but I think it's appropriate to put it there.
Thank you. Mr. Chairman, will we have the opportunity for more questioning? Or?
You will have a wonderful opportunity to question the second panel.
Okay. May we submit questions for the record?
Absolutely.
Ask the witness to respond. Okay.
Yes.
Thank you, Mr. Chairman.
Mr. Rogers.
Thank you, Mr. Chairman. Thank you very much for being here as well, and we've had the opportunity to have these discussions in classified chambers as well, and I thank you for your advocacy on this. Just quickly, and I think there's a lot of misunderstanding about these. Prior to the Patriot Act, could an FBI agent, through a legal instrument, go to a library and obtain records on a criminal matter?
Yes, absolutely. Grand jury subpoena. It was used in a number of cases that I could cite. Not a lot, but when it really matters, yeah.
And a great example was the Unabomber, Ted Kaczynski.
Right, who wrote this wacko manifesto taking credit or offering justification for why he maimed and killed innocent people. And one of the key pieces of proof in making the case against him, as I understand it, was the ability to go to libraries and verify that the obscure texts that were referenced in the manifesto had been checked out by him at a library near where he was living. A key piece of corroboration.
So just for those non-investigators, non-lawyers in the room, prior to the Patriot Act, the FBI or federal agency took a legal instrument to a library to obtain records to further the case of Ted Kaczynski without the Patriot Act, which was completely legal under the law.
Absolutely, and continues to this day, separate and apart from the
So what the Patriot Act did is say the same standard that we use for people who are blowing up citizens in the United States criminally, we're going to apply to these basically spies and terrorists today. Is that correct?
Yes.
From a layman's perspective.
Yes.
So this is not some great sweeping change in the way we approach civil liberties in the United States.
That's absolutely right.
That's to me is very, very important. Now, how would I, if I'm an FBI agent and I have a reasonable belief that this is connected to my investigation, what do I have to do? How do I get a legal instrument, and what is that legal instrument to go into that library if I think a terrorist is on, say, the internet and using that to communicate and further his criminal enterprise?
You have to get approval at a number of levels within the FBI, which you might know better than I, but it's a bureaucratic challenge to get supervisory approval and then take it across the street to Main Justice, where I work, and go to the Office of Intelligence Policy and Review, meet with one of the lawyers whose specialty is intelligence and dealing with the Foreign Intelligence Surveillance Court, explain to them what you want, why you want it, what your factual basis is, and they will help you prepare a written certification application to the FISA court explaining what you're doing, why this is relevant to that investigation, and then they will accompany you to a judge of the FISA court to seek a court order from that judge. And if the order issues, you'll be given that process, and you can serve that on the credit card company or the driver's license bureau or the bank, the places in which we've actually used this provision. We've never used it to get gun records or health records or even library records, and I hate to keep talking the library provision, and then you would serve that process and obtain those records for your investigation.
So this is really about business records, and any other records also happens to include libraries.
Yes, as I said, it caught those of us who do this for a living completely by surprise that anybody would associate it with libraries. Never occurred to me, and I don't know exactly how even the good librarians were told that this might affect them, because it never would have imagined in the world we inhabit.
So can an FBI agent stop along the road and say, you know, I've always been suspect of that Mike Rogers. I want to go in and see what he's checked out today, walk in, show his badge, and say, I want to see Mike Rogers' records, what he's checked out in this library in the last 6 months?
No, certainly not. He's got a lot of paperwork and federal judges between him and that. And I want to make sure I mention, and then we tell Congress every 6 months what we got the 215 order for, what we used it for. Sure. And we do a chart and send it to Congress every 6 months.
Secondly, can an investigator decide that I want to go and look in somebody's garage, house, bedroom, library, den, on my own, look around, and not tell anybody about it, and be in compliance with the law as it is under the Patriot Act today?
Absolutely not. No agent of any sort conducting any sort of investigation may enter a dwelling, a garage, an apartment, a house without probable cause and the approval of a federal judge. That federal judge sits on the Foreign Intelligence Surveillance Court if the search is sought to be conducted of a spy or a terrorist. That judge sits in a regular criminal United States District Court if the search is conducted in a criminal investigation. Both require, and this is a subject of great confusion, both require a showing of probable cause to a federal judge who must agree and then issue a court order to allow the entry and search.
I see my time is up. I wish I could follow up on that, but I hope you'll go through the process of what an agent must do in order to even get to the court, what that document looks like, and how much time and investment. This is not a simple process for people to go through in order to get even a delayed notice, let alone a search warrant in the first place. It is a very difficult, high legal standard that these agents and investigators must do. And I would thank you very much again for what you do. Thank you, Mr. Chairman.
Yep, Mr. Tierney.
Thank you. Mr. Comey, let me cover some ground because we have such limited time. We can't get into all the things we want to hear. But first of all, you're familiar that Justice Powell, in writing for the Supreme Court, has made an observation. I don't think you'd agree with it. Disagree with it. It says national security cases often reflect a convergence of First and Fourth Amendment values that are not present in an ordinary crime. And he talks about the tendency of government, even when they're benevolent and there's no bad motives, they sort of view with suspicion anybody who's disputing government policies. That's their nature. And the court goes on to say the price of lawful public dissent must not be a dread of subjection to an unchecked surveillance power. You don't have any problem with that, do you?
Certainly not.
Okay. So suppose there's a FISA record demand on a church or a college. It could be used to obtain a list of books or magazines or even a membership list of a controversial political or religious organization. I think that's, taken out of the library for a second, I think that's a concern that people have. All right. In the Doe versus Ashcroft, the New York case of last year, that court just essentially said, look, the national security letter power is thrown out in this instance. There was a failure to provide any explicit right of the recipient to challenge the letter, and the search itself it violated the Fourth Amendment on that basis. And it went on to say that automatic secrecy rule, the gag rule, violated the First Amendment. So those are some of the reasons some of us say, look, we should be able to keep a lot of that section of the law, but tighten it up a little bit here. So am I hearing you say that you agree that we can amend the gag order to ensure that counsel can at least be consulted by the person served? And just to make a clarification today, we're not talking about consulting terrorists. We're talking about the person served, which would be the official at the college or the official at the church or something on that basis. So do we have some sort of agreement that there ought to be some right that they can at least consult counsel about the fact they've been served, and that maybe they're supposed to turn over a list and they have a suspicion that this particular zealous law enforcement person, with all the best intentions or whatever, might be trying to get a list of a controversial political or religious group?
I think we do. Congressman, I think you're talking about two different provisions, though, if I could...
well, they're a bit related, as the
right,
court said.
and they are.
And the court sort of criticizes your office's attempt to separate them out too much.
Well, 250, we could, in theory, obtain an order under 215 to obtain records from a university. And again, I said at the beginning, people should question government power for a lot of the reasons you said. And government,
which is why we're going to tighten it up.
Well,
smart.
Here's, though, where 215 is a little different from what you described. To get those records, to accomplish the abuse that you're concerned about, we'd have to have a federal judge involved and then tell Congress what we had done every 6 months, where it had gone.
Excuse me, how does that stop you? All you got to do is certify to a judge, and then the judge must issue it. So that's not a real big hurdle to take. And reporting after the fact isn't going to do us a heck of a lot of good. So that's a good argument for why we ought to just tighten it up to make sure that we can accomplish what we intended to do with 215 and take away the concern of it being too broad. Let me move on for a second. You know, in a criminal matter, if somebody gets served with a grand jury subpoena, there's a big difference. That person has a right to challenge that order, don't they?
If someone receives a grand jury subpoena?
Right.
Yes.
Okay. But you don't have it in a FISA order. You don't ever get that right the way the law is written right now to challenge it.
No, in fact, that's why I said we support putting in a provision that allows someone to consult an attorney and to challenge it.
Good. All right. And then the last part of this is, you know, just how broad are we going to let the basis for issuance be? Some of us feel the idea of just using the standard sought for a national security investigation is a little too broad. Did I hear you say that you have a problem with the phraseology, specific and articulable facts giving reason to believe the records obtained for national security service? You think that's too tight?
I don't know, Congressman. My concern about specific and articulable facts is I try to figure out how that would affect a real investigation, and I always use Muhammad Atta's roommate, you know, a guy we don't know anything about except he lives there. Would I be able to check him out using 215 if I had to show, before I checked him out, specific and articulable facts to believe he's an agent of a foreign power? I don't think I'd be able to check the guy out, and I think everybody in the room would want me to check him out to get his bank records, his phone records. And so we prefer that we have an express relevance standard, because that's the way in this country we investigate, on a standard of relevance.
All right. So we have work to do on that. All right. Let me talk a little bit about roving wiretaps, the so-called John Doe roving wiretaps. Is there any feeling, a sense from your office, that that needs to be tightened up a little bit, that it's not enough to just have a broad physical description of somebody and then their ability to just tap any phone without designating what phone that might be?
No, because we don't understand it, nor does the FISA court understand it, to, as best I can tell, to permit a broad physical description. We have to have a human being that we've described with sufficient particularity that the FISA court can conclude that person is an agent of a foreign power. That really doesn't allow us to broad brush anybody beyond an actual human being whose name we don't know.
So what we have there is a disagreement on interpretation of law. Some people don't read that to be that specific, and that's the concern. But you would have no problem with language that everybody could agree on that reaches the end that you said, that there's a particularity of identification.
Yeah, if there's an ambiguity, like I said, we understand it to require that you don't know a guy's name, but there's a guy, and you can establish that there's probable cause to believe he's an agent of a foreign power. If there's some language that would simply enshrine that understanding, I don't know that I have a problem with it.
All right. Because I think we'd all agree that there's a little bit of a concern from following some unknown, unspecified person around from phone to phone and just tapping it could subject God knows how many Americans just having their information overheard or listened or interrupted.
Yeah, and we don't read the statute to allow that. We don't want that authority. We don't read it that way.
I'm afraid my time is up.
Yep, Mr. Thornberry.
Thank you, Mr. Chairman. I guess I want to ask kind of a going out the door sort of question. I agree that most of the concern about the Patriot Act is based on misunderstanding. I think there may be an undercurrent of concern based on the fact that the same organization has domestic intelligence and law enforcement responsibilities. I mean, I assume that's kind of why this wall was erected to begin with. And as a matter of fact, one of the witnesses in the panel to follow you basically says you may be talking about the same tools used in law enforcement, but in that context, they are gathering evidence for a trial, and that is a constraint upon what law enforcement officers may do. We heard arguments kind of coming from the other side that this culture of law enforcement restricts too much our gathering information about people who wish to harm a lot of folks. And so as a recent book by one of these wise circuit court judges talks about, we ought to have a separate entity that does domestic intelligence. And I'd be interested in your thoughts about that. What are the advantages and disadvantages of breaking out? And let me throw one more out there. The WMD Commission has basically said that the Justice Department needs to restructure itself in a way that kind of addresses some of these issues, both practical and civil libertarian. So I'd be interested in your thoughts.
The WMD Commission's recommendations, which, as I understand them, don't advocate the creation of sort of an MI5, a separate organization, are important, and that's something we're studying right now. But I very much oppose the notion, which I think Judge Posner has advocated, of creating a separate MI5 for a number of reasons. I think one of the great strengths of the FBI is that it is infused with a culture of the Fourth Amendment, Fifth Amendment, Sixth Amendment. Its people grow up in that environment. And I think that is a very healthy thing for intelligence gatherers. I worry very much that if we created a separate intelligence service in the United States without that environment, that culture, and culture really matters, that we would regret it 30 years from now. I don't think it is a break on our ability to do our jobs that we think about standards and lawfulness and process in the Constitution. I think it actually makes us better. I also think that when you're chasing terrorists, the notion of separating the people in contact with the street cops, making the bank robbery arrests, investigating the fraud cases from the people conducting intelligence investigations makes no sense at all. Counterterrorism is criminal and intelligence, and they merge in ways that are difficult to anticipate, difficult to describe. And if you separate those two forces, you will create separate cultures. And the MI5, I don't think, would work in this country. I think there's a number of other reasons why it is good. One of them is, one of the challenges we face is resisting the duty to warn. That particularly in the post 9/11 commission environment where folks worry about being held responsible for things, there's a tremendous incentive for people to push out warnings about things. I think the FBI's connection, almost symbiotic connection with state and local enforcers and responders, acts as a natural break on that tendency. I think if you created an MI5 divorced from those folks, you would in a way create a domestic warning agency, because the MI5 would simply be in a position to say, the sky is falling, you FBI, go hold it up. I don't think you want to separate the sky holders from those who say the sky is falling. I don't think that would be healthy for us. So I could talk about this all day, but I don't think that makes sense. I think some of the ideas that Director Mueller is trying now, and perhaps some of the ideas the WMD Commission has embraced to improve the operations of intelligence in a criminal environment, are something we need to really look at. But the idea of breaking them apart does not make us safer, in my opinion.
Mr. Reyes.
Mr. Chairman, can I take a bye until I get my bearings here? I just came from another markup. Thanks.
All right. Well, then we'll have to choose between Mr. Boswell and Mr. Kramer, since Mr. Boswell just walked back. You're on, if you're ready.
Ready?
Such timing. Well, I'll be brief. I got here late. I apologize, Mr. Chairman, and I've been called out a couple of times. But I'd like to associate myself with the comment you've made, Mr. Chairman, and Ranking Member Ms. Harmon. I think you're right on, and I think your testimony is one of the best I've heard. I think maybe we ought to put you on the road and be out there and explain to the American people, what this is all about. But going back to the September 11th, 01 events, everybody's in a high state of nerve, yourself and me included, all of us. And so we've had to take some steps, but I think it's timely, and I think it's fair, and I think it's reasonable that we have this review and have this, bring it right up here where it's in daylight on top of the table. And I think, Mr. Chairman, and that's what we're trying to do here, and let's talk about it, and hopefully the understandings can take place. Now, I've learned some things here today, and I appreciate it, and believable. But at the same time, it's always fair in this United States of America to question. And if we ever lose that, we lose a lot, and we don't do that. And so I think it's extremely important we're having this hearing, and appreciate your presence. And I think that Ms. Harmon made some very good points in her opening remarks, and I'm hearing you address them. I'm going to offer to yield some of my time back to her if she wants it, to make sure she is getting those questions answered, because I thought they were well stated. And so I thank you for being here, and I don't know what you're going to do. We've talked about people being lawyers. I don't run from the fact that I'm a farmer, soldier, or businessman. But you know what? In fairness to you that are lawyers, if I could back up, which I can't, so I can be pretty loose about this, I would go to law school. I think it's a very respected profession, and certainly part of what makes this country great. So with that, thank you, Mr. Chairman, and Ms. Harmon, would you like some of my time?
I've taken plenty of time. Thank you, Mr. Boswell.
All right.
The gentleman yields back his time. Thank you. Mr. Tiart.
Thank you, Mr. Chairman. It sounds like Mr. Boswell had another rendition of "Don't let your kids grow up to be cowboys."
I'm not so sure of that.
Mr. Comey, thank you for being here. Critics often cite that the Patriot Act has blurred the lines between criminal investigations and foreign intelligence investigations. And some would even argue that they've brought the barriers down. In criminal cases, we notify individuals when they're under investigation. They have the right to defend themselves. We disclose evidence so that they can prepare their defense. Those who allege the Patriot Act has gone too far quite often say that there's no notice of any investigations that are going on, that records are gathered during an investigation and never disclosed unless you go to court, and that individuals are investigated without notice, and that this evidence can be passed on to others within the government without notice. Are those fair charges? Have the lines been blurred or removed between, or ignored, between criminal and Patriot Act, between criminal investigations and Patriot Act investigations?
No, they haven't, Congressman. We are a nation of laws. We are an FBI of laws and procedures, Department of Justice of laws and procedures. What the Patriot Act allowed us to do was to have the people not have artificial distinctions between people trying to figure out whether to bring a material support criminal charge against someone from those trying to gather information about those same someones to prevent another terrorist attack, to allow the two of them to talk to each other and decide which tools will be better, when is the appropriate time to bring the charge to protect the American people. But taking into account our need to collect information. The challenge for those of us who believe this is a good thing is that it's all very complicated and mysterious to a lot of folks, because what we do in intelligence gathering is by necessity secret. I heard it best described by Jim Baker, who runs our Office of Intelligence Policy and Review, who said, yes, there is less disclosure long-term on the intelligence gathering side. We err in favor of keeping things secret long-term, whereas on the criminal side, we err on the side of giving notice that an electronic surveillance was conducted. We bring things into court. And he said the reason that we do that is because of the stakes on either side. The stakes are unimaginably high on the international terrorism side. And we account for the secrecy by protecting U.S. person information, by having rigorous rules about the way we can collect, store, and disseminate, share with others information about U.S. citizens or permanent residents that we don't have on the criminal side. So we strike a balance. There are tremendous restrictions on our ability to share among ourselves or disclose to anyone information about a United States person. That balance, I think, is appropriate on the intelligence side. We need to protect information that we collect about U.S. persons, but at the same time we need secrecy to make sure that the people we're tracking don't know that we're on to them, and so that we don't disclose sources and methods, something this committee knows more about than anybody in the government. On the criminal side, we strike the balance differently and appropriately. So I don't think there's been a merger. I don't think there's been an inappropriate erasure of standards on either side.
Well, I think a lot of the concerns are that when you cross these lines, since some of it's held secret, people don't know when they're under investigation. That could create a problem. I know in the rules of the House, we just recently voted down that we don't even have to notify each other when we're under investigation, which I think is a travesty. But we allowed that rule change to slip away.
And on the criminal side, Congressman, if I may, all the time we investigate without people knowing they're being investigated. I mean, I've conducted dozens, maybe hundreds of investigations where the person I'm investigating never finds out because we conclude at the end of the day that they didn't do it or there isn't sufficient evidence to bring a charge. I think that's a good thing. That's one of the positive things about grand jury secrecy in particular. Innocent people should not be smeared. The guilty should not get away. That's why secrecy is important on the criminal side as well as on the intelligence side.
There's also this concern that some sections of the Patriot Act are treated differently than others. Section 212, which authorizes disclosure of emails and stuff that's electronically passed, and Section 217, which allows real-time surveillance. The allegation there is that there's never any judge that gets a report on this, that there's no time limits on disclosure, that you can continue this for a very long period of time without revealing any or making any disclosure or filing with anybody. And there's never any notice to individuals that they have been investigated. And again, that this could be passed on to some other agency. Is that a valid concern about the Patriot Act?
I don't think so, Congressman. Section 212 allows an electronic communications provider in a situation where lives are in danger on an emergency basis to share information about either a telephone number account or an account, internet account, with law enforcement, and we've used it to save a young girl from Pittsburgh who was enslaved by a kidnapper. We've used it when lives are in danger, and if it produces evidence that results in a criminal case, people learn about it because the evidence is disclosed as part of the criminal discovery. If it doesn't lead anywhere, it doesn't lead to an accusation against someone, you're right, there is no notice to that someone, nor do I think there should be. As unsettling as that sometimes is at first blush, but again, I don't know that the American people want us going and telling innocent people, you were investigated because you were accused of this, that didn't check out, or telling your neighbors, or sending a card through the mail so your postman sees you got something from the FBI to your home, and then your kids open it and say, oh, Dad, you're investigated by the FBI, and I'm sorry I opened your mail. I don't know what that people would want us to do that if they think through how we conduct investigations and why secrecy matters.
Thank you, Mr. Comey. Thank you, Mr. Chairman.
Thank you. Well, Mr. Reyes, are you ready? Mr. Reyes.
Thank you, Mr. Chairman. I appreciate the consideration, and I apologize for the witness, but we had a markup in veterans, and I had to be present for that. I've got perhaps a couple of observations, because before coming to Congress, I was in federal law enforcement, so I had an opportunity to work a lot with U.S. attorneys, assistant U.S. attorneys, and get a kind of an insight as to how we developed the authority to get both wiretaps, search warrants, and other means to be able to successfully investigate and prosecute cases. There are a number of concerns with the Patriot Act, one of which you had addressed in your opening comments that I did hear, and that involved that individual where with drugs that they stole his car and were able to notify him subsequent to that. But my question to you is along the lines of if we're using the Patriot Act mostly in the context of what you've addressed here in that particular section for criminal acts, doesn't it make more sense for us to give that authority within the criminal context for investigations rather than rely on an act that is specifically targeting those that would be a threat to the national security of the country?
Congressman, I don't know that the Patriot Act, that anyone warranted that it was exclusively designed for counterterrorism. That's obviously its primary purpose, but as you know, it made changes to a whole bunch of statutes from sort of soup to nuts, some of which are very useful, those changes, in non-terrorism cases, some of which enshrine tools that we in federal law enforcement have used for a long time, delayed notice search warrants. My response when folks ask that question is, well, let's talk about the tool and see if it makes sense. If it doesn't make sense, then people should talk about changing it. If it makes sense, then I don't know what difference it makes that it was enacted as part of the Patriot Act package or not.
Well, let me just tell you that the president of the American Library Association, a lady named Carol Bray Casiano, is the director of the El Paso Public Library. And in a number of conversations, the librarians in general are very much concerned about the ability of the federal government to come in, seize records, and their largest concern is that they can go on what is commonly referred to as a fishing expedition in terms of who's using the library. They would like, and have told me directly, they would like a tightening up so that there's a specific nexus to a particular case and a reason for a federal agent to be there to get their data, because they're very concerned that this would add yet another challenge to getting people to use the public library. So in that context, how do you respond to the concern that or maybe it's a perception, because we did have a closed hearing with the director of the FBI who was very clear in addressing that issue. But how do you address those concerns from people that are concerned about losing the tie to privacy that normally Americans depend on?
That's been one of the most painful parts of the Patriot Act debate, or the follow-on to the Patriot Act, has been that librarians, who in my experience are really good people, and I'm not just sucking up to the First Lady, I mean, they are people who care about civil liberties, who care about kids and raising kids right, have gotten so upset about this. And I've tried, and the Attorney General met with, I believe, that lady and the American Library Association a week or so ago, so that we can try and explain, we should all agree that libraries shouldn't be a safe haven for pedophiles, for terrorists, for bad guys. Nobody wants that. So the question is, what is reasonable for law enforcement to be able to do in that environment? We think it's reasonable for law enforcement in an international terrorism investigation to be able to go to a federal judge and warrant that the records sought are relevant to that international terrorism investigation, and on that basis get legal process to obtain the records. We also think it's reasonable to put in the statute a provision that allows the librarian or the library to challenge if they think it's inappropriate that they receive this order. But we don't think it's reasonable for the protection of national security to make the bar so high that we create that safe haven that all of us worry about. We know bad guys use libraries. We know terrorists use libraries. Nobody wants them there. Everybody wants us there tracking those guys. So we should talk about what's reasonable for us to be able to do in that environment.
Very good. Thank you, Mr. Chairman.
Thank you. We will recess for, I think we've got one vote, so we'll recess for about 10 minutes, and we will be back.
Thank you, Mr. Chairman. Obviously, none of us planned what just happened in the skies around Washington, and the good news is that whatever that emergency was, it is over, and we will learn more about it later. The bad news is that we lost our members, and I know the chairman's going to announce rescheduling the rest of this hearing. I just want to say on the record, because I may not be able to attend the rescheduled date at the rescheduled date, that I think this second panel is extremely important. Unlike the other body, as we say around here, unlike the Senate, we are hearing from outside witnesses, and their range of views will be very useful to this committee as it thinks about how to clarify the intent of the provisions of the Patriot Act. I, for one, want to be heard that the Patriot Act is a valuable instrument, but that some fine-tuning is now necessary 4 years out. And I would think, based on the questions of our first witness, that the Justice Department is listening and is in general agreement. And now the question is, how do we craft refinements? And hopefully this panel next week will be able to think even more carefully about that, since they were all here and heard the testimony on the record with the first witness. So I do apologize to everyone for the inconvenience, and I yield back my time to the chairman.
I thank the gentlelady, and I agree with the gentlelady from California. We're going to go off record. For the record, I would like to state I'd feel much more comfortable if those were Navy pilots up there instead of Air Force pilots protecting us. But for the record, we're going to try and reconvene this next Thursday. And because we can't get staff in and get the members in, we're going to adjourn this meeting for the record. And we want to thank you. I was looking forward to this hearing, and we will see you next time. We hope it fits within your schedule. And with that, this hearing is closed.